All right. So first of all, the first thing to understand is I'm a California attorney and mediator. And I'm speaking to California law. Now, there may be a lot of crossover with other states. It's very, very possible. I think family law is, um, generally speaking, is one of those areas of law that is relatively comparable across states, but I think that's a matter of opinion, and it depends on what element of it you're talking about. Um, and so I can speak to the California law context. Right away, there's sort of a really important thing to understand, which is that in family law, especially when we're talking about divorce, so we're talking about sort of a reorganization of the family enterprise. You can kind of think of it as like a Chapter 11 bankruptcy. It's sort of a reorganization. The family still exists afterwards, but it looks different. There, we talk about custody, but custody really in California is two separate topics. There's physical custody and there's legal custody. And to put it very simply, physical custody is where the children are, where, with which parent are they, where do they sleep, where do they spend time. Legal custody is decision-making authority over the children. So that could be decision-making authority over where they go to school, where they will go to camp, which doctor they will see, which medical procedures they will have or will not have, even up to kind of what religion they're practicing, things like that. Now, it's always possible, just I'm speaking the broadest terms, and then kind of narrowing the funnel down here. It's always possible for one parent post-divorce to have sole custody on one or both of these topics. They could have sole physical custody, where they've got nothing to do with the other parent. The children spend no time with the other parent, or they could have sole legal custody, where they have sole decision-making rights. Certainly, if you have sole physical custody, you're going to end up having sole legal custody, because it would make no sense to have one parent have the children physically all the time and the other parent have decision-making authority over the children. So they do tend to track each other to some extent, right? If you've got the children with you all the time or even most of the time, probably the legal custody is going to make sense to be in your hands, typically. But it's all variable. And by and large, having sole custody, physical or legal, is rare. It's rare because in our society, the law has a strong bias in favor of having two involved parents. So there's a legal phrase which is not coming to me right now, but it's something like children are best served by having a steady and continuous relationship with both parents, if that is possible. When would it make sense for a child, depending on the needs of the child, to have more physical custody time with one parent over the other? That might depend on the particular needs of the child and one parent being physically more set up for that, having training in how to care for the child, or just simply, during the marriage, having been the parent that was caring for that child just more of the time. And it's just the way it is. They know how to care for this child with that child's particular needs. And it really does kind of militate in favor of status quo to some extent. If that was the primary caretaking parent during the marriage, and they are arguing to be the primary physical custody parent post marriage, um, there is a stronger argument there when the child's needs are more specific, right? Legal custody can also be joint, just like physical custody can be joint. Decision making can be joint too. Where does our child go to school? Maybe it's something that we need to agree on. Even post marriage, something that we need to agree on. Where are they going to go to camp? What kind of medical procedures are they going to have or not have? Who is their doctor? These might be joint legal custody things, or legal custody can be split. You might have decision-making authority on schools. I have decision-making authority on medical. It's possible. You can kind of do this any which way you want to, which is sort of the broad framework here.
When would a parent need an attorney or a special ed attorney?
It depends, but a parent may need an attorney or special education attorney in a variety of situations, including but not limited to like custody disputes, child support issues, special education needs, disputes with schools or school districts, or any legal proceedings related to the welfare of the child.
It's important, at the very least, for a parent to know whether they can co-parent. What does co-parenting mean? It refers to, are they able to share parenting of the children? Are they able to, even if they're living apart, make decisions about the child or children? So can they do what's best for the child? You know, one of the main things to consider is, has there been domestic violence? Is there that power and control when one person exercises their power or their belief of authority? It's my way, my decision, my choice. So it's really important to look at each individual as a family, as their case, not to generalize. But questions that we thought of that might be helpful are, has the non-custodial parent, and that's the parent that the child does not primarily live with, been supportive of the child? Has a non-custodial parent been supportive of the child's disability, if a child has a disability? Has the non-custodial parent been supportive of the child's needs for services, if any services are required? Has the non-custodial put up any barriers for the child? Has the non-custodial parent created obstacles when services are required? Does the non-custodial parent have the child's best interest at heart? And there's a definition of what best interest is. I'm happy to share that with you. But I'll go forward with a few other questions, general questions that we have that parents should think about. Does the custodial parent, or the parent who the child primarily lives with, have orders? And are those orders specific? Is there an order that if services are required and the non-custodial parent who has joint legal custody cannot agree with the custodial parent, then possibly should I get a specific order allowing the services that are necessary and required? What is the child's relationship with the non-custodial parent? If the non-custodial parent has not previously been involved in the child's care, is there any limitation on that parent being involved in the future? Those are very general questions that a parent has to think about. Can we do this together? Does the other parent agree with what is the best for our child? And I said that I would define what is in the best interest of the child. So the court or custody must be awarded according to the child's best interest, and that's pursuant to Family Code Section 3040 subsection A. And in determining the child's best interest, the court must consider the child's health, safety, and welfare.
So if the parents have joint custody, then there's this assumption that both parents have equal rights and responsibilities to make all those decisions that are related to raising the child, like healthcare, what services they need, their education involvement, anything related to welfare of the child. And so even though one parent's been primarily, like you said, the primary advocate in the past, when joint legal custody orders then come into play, the primary advocate then might have to start sharing some of that essential information and those decisions with the other parent, even though historically they weren't as engaged, to give that other parent the kind of the opportunity to be an active participant, even if in the past that wasn't the case. Regarding public benefits, the parent who has physical custody of the child at least 51% of the time is the parent who could apply for public benefits. So that's not really playing into joint legal custody. It's more about the physical presence. And only one parent can apply for those public benefits generally. One parent must be the representative payee, for example, for SSI or SSD benefits when the child turns 18 and older.
What if one parent disagrees with therapy recommendations and refuses to agree?
So if one parent disagrees with therapy recommendations for their child and refuses to agree, it's really challenging actually to resolve this kind of disagreement. So depending on the situation, I'll lay out a few options that could be available. So first, parents may seek assistance of a mediator or family therapist, which I talked about above, to help them work through their disagreements and find a solution that is in the best interest of the child. If this is not successful, the parent who agrees with the therapy recommendations may seek a court order to enforce them. A court may consider evidence from both parents, as well as input from the child's therapist or other healthcare professionals before making a decision. But it's important to note that in cases where therapy is deemed necessary for the child's well-being, courts generally tend to favor the opinion of healthcare professionals over parental preferences. The court may order therapy to be provided even if one parent disagrees, as long as it's in the best interest of the child. So the overriding principle in most of these cases, if there's any doubt, is mostly that what is going to be in the best interest of the child. Steps to resolve these issues would be going before a mediator. And if that doesn't resolve, then going before a judge and then getting a final judgment. But as always, the best interest of the child is going to be what's considered to be the highest priority when you're dealing with any issues involving parental disagreements.
What about IEPs? What about IHSS? What about respite care? You know, what if you have disagreement about these things? Well, who has the authority on this? Who has legal custody on this matter? So somebody might have sole legal custody, in which case what the other person thinks is irrelevant. But getting sole legal custody awarded to you in court is a difficult thing. Typically, a judge is not going to award that to you, because why should you have sole decision-making authority over this child? You might, maybe if you kind of present this in court, you might say, I really should have sole decision-making authority over education, over IEPs, over communicating with teachers, this aspect of legal custody, because I'm set up for it, and it would just cause all kinds of problems if that's joint. We just can't work together. We have a history of not working together. It's really useful if it can be kind of unilateral. Maybe a judge will buy this and maybe they won't. And judges are just people, and they're kind of coming at this with their life experience as well. They might like the way that this sounds. They might think that sounds reasonable. I get you. Sounds right. They might not, especially because your spouse is there on the other side telling a very different story, right? And so it's a challenge. My best advice would be to come to those kind of settlement processes with your priorities clearly in place, understanding this kind of framework of IEPs and of IHSS and all these needs that your children have, and coming with your priorities clear about how is this going to work, and would you be willing, you come at this as a question, would you be willing to grant me sole legal custody over these issues, and I can navigate these well, and it might end up being very problematic if we're sharing legal custody on this. And I'm not sure you want legal custody on this, because I'm not sure you know what you're doing, right? I've been handling these issues up until now. So that's kind of the broad scope answer to a lot of these questions. Is it's going to depend on who has authority, right? And who has authority is going to be based upon either how well you did in court or what agreements you came to. If you're not in court, what you settled on.
If you cannot agree to something, then you're going to want to get that order. If it's for joint legal custody, at the very least, when the parents cannot agree to something, then one must be able to make that decision. But it has to be something that is, one parent has to have the final decision authority if the parents are not able to agree after a meaningful attempt to collaborate and co-parent.
Say the therapist tells you, oh, the child said this in the therapy session. Have you got an obligation then to disclose that to the other parent? Or is there, how does those kind of ethical issues play out?
Right. So we're leaving out of this kind of, for me, kind of my favorite part of the whole thing, or where I would really spend the most time out of the whole thing, which is sort of the ethical side of it. Really is sort of what is the right and peaceful and graceful thing to do. And ultimately, it's just my firm belief that in the long term, conducting yourself in that way, even with your ex, regardless of how you feel about them, is ultimately going to accrue to your benefit and your children's benefit. It just does. It really isn't about you; it's about your children, ultimately. And so, if the therapist tells you information that is just kind of on its face, it would be critical or valuable for your child's other caregiver to know about, it seems that it would behoove you to tell them. But again, I'm speaking here kind of in an extra legal kind of way. In my role as a mediator, I get to do that a lot. And often that's really what people need. I mean, truly, is to kind of be reminded of those things, of just how important it is to be considerate and gracious in all this. But I know that the question is, okay, but what are my rights, right? What do I have to do? What do they have to do? What are the rights, which is sort of that hard legal edge to it. As far as the other parent goes, the fact that you have joint legal custody with the other person doesn't impose an obligation on you to kind of proactively send information to them, unless that is written explicitly into the judge's orders or into your settled agreement. It's actually a fairly standard kind of agreement in joint legal custody, is after there's a medical procedure, let me know what happened, something like that. I mean, it's an easy one to kind of mess with to some extent, because I mean, how detailed does that report need to be? And that's why the other parent can always fall back on just getting the medical records if they need to. Same thing with school records. It works the same way. The school needs to divulge those records to a parent that has joint legal custody.
How do they split up the IHSS if they're supposed to split everything like custody 50-50, but one parent has always been the IHSS provider? Is that going to change? Who's going to decide? Is that the county deciding how that would be split up, or would that be part of their settlement?
If both parents are available to be the child's IHSS provider, hours are assigned based on the child's needs when the child is in each parent's home. And so that would be dependent on what the county allows. And you may know that there are so many hours, allowable. And if your client, the parent does not agree with the orders that are being made, then it's requesting an administrative hearing, and not in the family court. So the child needs services in whatever home the child is in. And this is going to be, as you asked, whether it's a county thing. Yes, it's going to be a county thing. It's going to be requesting an administrative hearing if only hours are provided here, but not here, but there's an order that the child should be at both places and both parents are exercising, the custodial rights over the child. So not a family law setting.
When can the child make their own decisions if there is a disagreement between parents?
Well, it usually depends on the age and the maturity level of the child, but generally children under the age of 18 are considered minors and not legally able to make their own decisions in cases of disagreement between parents or divorced parents. But as children grow older and they become more mature, and they can make more informed decisions, and sometimes their opinions and preferences may be taken into account by the court, determining, custody or visitation determinations and things like that.
To clarify, that doesn't differ whether the parents are together or separated, right? It's still the age limit.
Yeah, that's correct.
And when can parental authority to make these medical decisions for their children be challenged?
So the parental authority to make medical decisions for their children can be challenged if there's evidence that the parent is making decisions that place the child at significant risk of harm. In some of these cases, a court may appoint what's called a guardian ad litem to represent the child's interest. That would be somebody separate and apart an adult who's assigned to the case. And in that case, they may even terminate the judge may terminate the parental rights if the parent's actions are deemed to be severely detrimental to the child's well-being.
What's the best way for them to approach, when if they get that situation where the family law attorney doesn't know about IHSS, doesn't know about regional center, and the special education attorney doesn't know about family law? What's the best thing for a parent to do in that situation?
The answer is to utilize multiple attorneys, really, because look, any one attorney can kind of learn a bit in a different area of law. But family law attorneys who are watching people who are not family law attorneys practicing family law, we do that with some horror, because there's a lot to know, and so to just kind of step into it and dabble is probably not the best idea. And I can only imagine that a special needs attorney would watch me trying to dabble in that area and might also be really scared for what havoc I would raise. So the best would be for them to coordinate a bit. So you might just kind of, utilize more than one attorney and let the attorneys speak with each other. Attorneys are really good at collaborating with each other, and at least in my experience, and recognizing where they don't have subject matter expertise and need the help of somebody else who does.
What's your advice, on a parent going to see a mediator or an attorney, and they don't know about these issues?
Providing a lot of information and documentation. So if there's records from the school, if there's, records from different medical providers, if there's things you've noticed about the changes in the child's behavior, different patterns, and any information you can provide, I think just front loading that and trying to give as much information as possible really helps with educating the attorney or the mediator or whoever it might be that you're talking to on the specific situation, because like we've said repeatedly, every single case is different, every family is different, and so there isn't a one-size-fits-all solution. And without that information, then it might just be assumed that maybe a joint custody order and a 50-50 timeshare would be appropriate because it's right down the middle, but that may not be best for the children involved. So giving all that information so that we can work together and figure out what truly is in the best interest of that child and that family is what I'd recommend for those parents.